The bailiff called the case through the low hum of New York City probate court, distant horns and hurried footsteps leaking through the walls as my wealthy brother strode in, like the room already belonged to him, razor-sharp charcoal suit announcing certainty of victory. His attorney, Brian Ward, placed the motion on the table with surgical precision. "Your Honor," Brian announced, tone smooth but edged, "we move for immediate transfer of the entire estate to my client effective today." Behind him, my father Gary and mother Elizabeth nodded in practiced unity, faces set in rehearsed resolve. Gary's jaw locked as if I were nothing more than an obstacle, Elizabeth's folded hands disguising calculation as grief. The judge scanned the papers and fixed his eyes on me. "Ms. Kimberly Scott, do you object?" My brother's mouth curved, waiting for me to falter. I didn't. I straightened palms steady. "Yes. I object." Brian's smile thinned. On what grounds? I met his stare. "Not yet. I'm waiting for the last person to arrive." My brother laughed sharply. "There is no one else." Gary shot me the familiar glare reserved for public embarrassment. "You always do this." The judge leaned back, irritation rising. "This is probate court, Ms. Scott. Make your objection legal." "It is," I replied evenly, "but the explanation isn't mine." Brian stepped forward. "Emergency authority is required. Ms. Scott has obstructed progress. The assets demand protection, and my client is the responsible party." Elizabeth sighed softly. "She's grieving, Your Honor. She doesn't understand." My brother's eyes bored into me. "I'm preventing collapse. Grandpa would expect proper handling." The judge read again. "The petition seeks full authority and alleges the respondent is unfit." "Precisely," Brian said. "Grant it now." The judge looked at me. "Your objection." I stayed still. "You're being asked to rule without the full record." My brother scoffed. "There is no other record. He's gone." I spoke quietly. "The person who actually controls the inheritance." My brother blurted, "That's me," then faltered as the judge's gaze shifted. Silence sealed the room. The doors opened with controlled precision. A man in a plain black suit crossed the floor, envelope in hand, indifferent to wealth and tension. He stopped at the clerk's desk and said my name. "Ms. Scott." He placed the envelope down. "For the court, from the trustee." The judge read the sender and froze. "That can't be," he whispered. In the crowded courtroom, Brian Ward approached the bench with confidence. He cleared his throat once and launched into urgency, stressing that the estate's holdings, particularly the business investments tied to my grandfather's legacy, faced immediate vulnerability without court intervention. He argued that I had demonstrated clear unwillingness to cooperate and lacked the expertise required to oversee complex assets, especially those linked to ongoing commercial ventures that demanded decisive, experienced leadership. My brother sat straighter at those words, arms crossed loosely, a subtle nod of agreement crossing his face, as if Brian were voicing his own thoughts verbatim. My mind flickered back to the months following Grandpa's first serious fall. He had quietly asked me to move in closer help with medications and meals, while Kevin remained perpetually unavailable, citing endless meetings for his latest startup push in Silicon Alley. Calls went unanswered. Visits were postponed with vague promises of next quarter, and Grandpa's disappointment grew silent but deep. Now Kevin sat here positioning himself as the savior of that very legacy, ready to liquidate or redirect everything to shore up a company teetering on the brink, as though years of absence counted for nothing against his current financial desperation. Gary leaned in just enough for his low voice to reach me alone. "Enough of this nonsense. You're turning this into a spectacle and dragging the family name through it." The words carried the same heavy disapproval he had used when I was younger and dared to challenge family expectations. Elizabeth followed with her softer contribution, eyes lowered in feigned concern. "She's still overwhelmed by the loss, Your Honor. She isn't thinking clearly about what needs to be done." The judge raised an eyebrow and turned directly to me. Counsel has presented procedural urgency. What is the exact legal foundation for your ongoing objection? I kept my breathing controlled. The foundation is that approving immediate transfer would bypass the requirement for a complete evidentiary record. The court must review all relevant documentation before determining fitness or potential interference. Brian interjected without missing a beat. The existing record is more than adequate. Further delay only heightens exposure to risk and diminishes value. My brother tilted his head slightly, the corner of his mouth lifting into that signature smirk he reserved for moments when victory felt inevitable. As CEO of a rising tech firm, he had grown accustomed to commanding rooms, closing deals with sheer force of position and confidence that money would always follow. He looked at me now like someone who had already won, certain that status and resources would tip the scales once more. Inside, a steady certainty took root. They were convinced the inheritance was theirs by right, that control was simply a formality away. Yet the consequences of their rushed maneuvering were already ripening. Whether they had begun to taste the bitterness or not remained to be seen. The judge tapped his pen once against the file. Considering the motion alleges obstruction and unfitness, if the petitioner believes the record sufficient, why not proceed to evidence now rather than seek blanket authority? Brian adjusted his stance. Because time is the enemy here. Assets tied to market-sensitive investments could depreciate significantly if management remains stalled. Gary shifted in his seat, impatience flickering across his features. We're trying to protect what Victor built, not tear it down with endless delays. Elizabeth added quietly, almost to herself, she doesn't see how much is at stake. I felt the weight of their combined stares, but kept my focus on the judge. The stake is Grandpa's intent, not expediency. Rushing judgment ignores that. My brother exhaled through his nose, the sound barely audible but loaded with dismissal. He leaned back, fingers drumming once on the armrest, a small gesture of impatience that betrayed nothing of doubt. Only certainty that the court would eventually align with logic and power. The judge held my gaze for a long second before speaking again. Very well. If the objection stands on the need for a full record, we'll address that directly. But make no mistake, this court does not entertain tactics without substance. The air in the room thickened further. The distant city hum outside was a faint reminder that life continued beyond these walls, while our family's fracture played out in slow, deliberate strokes. They thought they held the upper hand, that their version of responsibility would prevail. But the truth Grandpa had quietly secured was closer than they realized, waiting to surface and rewrite every assumption they had brought into this room. Seconds later, the heavy doors swung open in the noisy New York courtroom. A man in a plain black suit stepped through, carrying only a single envelope. His stride was purposeful and completely detached from the charged atmosphere. He walked directly to the clerk's desk, without glancing at my brother, my parents, or anyone else, raised the envelope and spoke my name with calm precision. Ms. Scott. The judge paused mid-sentence, reached for his glasses, and watched intently as the man placed the envelope on the desk. This is for the court from the trustee, the man said. The judge accepted it, read the return address. Manhattan Trust Bank, and his posture changed subtly. He opened it carefully, extracted the document, scanned the opening lines, and began reading aloud. Assets were placed into a revocable trust, and upon the death of Victor Scott, became irrevocable. Successor trustee is Manhattan Trust Bank, Trust Department. He paused to let the words register, then continued. And this includes a pour-over clause which directs any remaining probate assets to pour directly into the trust, rendering separate probate administration unnecessary. The courtroom seemed to shrink. My brother froze mid-breath, his earlier certainty replaced by a rigid stillness. Brian Ward leaned forward slightly, attempting to regain footing. Your Honor, probate jurisdiction still applies to any non-trust property. The judge didn't lift his eyes from the page. The petition demanded immediate transfer of the entire estate. This certification confirms the probate estate is minimal, The bulk is held in trust. Therefore, the motion overreaches. My brother rose partway to his feet. That's not possible. The trust can't override court authority here. The judge finally looked up. Counsel, the document is clear. The trustee holds primary control and the pour-over clause ensures nothing falls outside its scope. Your request for blanket authority is denied. Kevin's face drained of color, his hands pressed flat against the table, as if anchoring himself. Gary reached across and gripped Elizabeth's hand so tightly his knuckles whitened. Her expression shifted from composed to ashen, the realization hitting them simultaneously that the control they had assumed was theirs had never been within reach. The judge kept reading. The no contest clause is explicit. Any beneficiary who petitions contrary to trust terms forfeits their interest. Brian stood quickly. We dispute the validity of that clause and request time to review. The judge shook his head. You can dispute, but the clause is enforceable. The filing of this motion may have already activated forfeiture. My brother's jaw clenched visibly, his eyes darting to Brian, then back to the judge, as though searching for a lifeline that wasn't there. Gary's grip on Elizabeth's hand tightened further. Their faces pale, the sudden loss of leverage sinking in like cold water. Elizabeth's breathing became shallow, but she said nothing. Gary stared at the floor, his usual authority evaporated. The judge addressed the representative from the bank. Sir, does the trustee recognize this petition? The man answered without hesitation. No, Your Honor. The trustee will administer solely per the trust instrument and request dismissal of any attempt to seize trust-controlled assets through probate. The judge nodded once. Motion denied. The trust governs distribution. The courtroom held its breath as the weight of those words settled. My brother sank back into his chair, fingers curling into fists. Brian whispered urgently, but the damage was already done. Inside, a quiet question formed. This moment made me wonder. Had they ever truly considered the real consequences of pushing so hard against what Grandpa had carefully planned? The truth he had secured was now undeniable and irreversible. The judge set the papers aside. We'll mark this received and proceed accordingly. The representative remained standing calm and unmoved, as though the family's unraveling held no more significance than routine paperwork. The shift in power was complete and final. The inheritance Grandpa intended would be protected exactly as he wanted, regardless of how fiercely they had tried to claim it for themselves. The judge turned the page, his expression hardening. He read the clause aloud with deliberate emphasis. Any beneficiary who files a petition to seize or contest trust assets, contrary to its express terms, automatically forfeits their entire beneficial interest. Brian Ward rose swiftly. Your Honor, this clause was inserted under circumstances that warrant scrutiny. We dispute its validity and request an immediate stay to allow thorough examination of execution details. The judge placed the document flat, his voice cutting through without hesitation. You may dispute validity in the appropriate proceeding, but the clause is unambiguous and fully enforceable under New York law. The filing of this very motion seeking immediate transfer of all inheritance has activated its provisions. Brian adjusted his stance, attempting to regain ground. Your Honor, equity demands we not penalize a good-faith effort to protect family assets. A brief delay would prevent irreversible harm. The judge shook his head. Equity does not override clear contractual language, counsel. You received the complete trust packet, including this clause, via certified service yesterday, yet you chose to proceed with a demand that directly violates it. My brother's face lost all remaining color, the flush of confidence replaced by a ghostly pallor, as though the millions he had counted on evaporated in real time. His hands clenched the table edge so tightly the wood creaked faintly. Brian tried to smooth the moment, his tone shifting to careful deference. Your Honor, this outcome appears disproportionate. We respectfully ask the court to consider the intent behind the petition rather than a strict technical trigger. The judge leaned forward slightly. The intent behind the petition is precisely what the clause guards against overreach. You filed knowing the risk. The consequences are not unforeseen. They are the direct result of your actions. My brother exhaled sharply, a sound that carried more defeat than anger. His shoulders dropped, the posture that had commanded the room now slumped under invisible weight. Brian placed a restraining hand on his arm, whispering something urgent, but the words fell flat against the judge's unyielding tone. For the record, the judge continued, the trustee has confirmed they will enforce the forfeiture provision pending any future challenge. This court will not interfere with a valid instrument merely because the petitioner dislikes the outcome. My brother stared at the bench, his eyes narrowed in a mix of disbelief and dawning fury. The smirk that had defined him moments earlier was gone, replaced by a tight line of lips and a faint tremor in his jaw. Gary sat motionless, his usual authoritative presence diminished. Elizabeth's breathing quickened visibly, her hands twisting together in her lap. The family's collective certainty was fracturing under the clause's cold precision. The judge continued, the no contest provision exists to preserve the settler's wishes exactly as expressed. Any attempt to circumvent them through aggressive litigation carries this penalty. It is not punitive, it is protective. My brother finally spoke, his voice low and strained. This can't be the end. We have grounds to fight this. Brian nodded vigorously. Your Honor, we will file the necessary contest promptly. But the judge cut across. Promptly or not, the forfeiture stands until adjudicated otherwise. The motion is denied. The trust governs all distribution. The courtroom felt smaller, the weight of the words pressing down. My brother sank deeper into his chair, fingers loosening their grip as resignation began to settle. Brian gathered his notes with measured movements, his professional facade intact, but the defeat clear in the slight slump of his shoulders. The judge addressed the clerk. Prepare the order reflecting denial and invocation of the clause for the trustee's records. My brother looked across at me for the first time since the envelope arrived, his gaze no longer triumphant, only hollow. The plan Grandpa had set in motion years earlier was unfolding exactly as intended. They had handed the court the very tool to strip them of what they tried to seize. The clause had done its work silently and irrevocably. Inside, a quiet satisfaction took hold. Grandpa's foresight had turned their haste against them. They had built their own trap step by step, and now the door had slammed shut with no key in sight. The judge closed the file with a soft snap. We'll adjourn briefly to allow counsel to confer. The consequences were no longer theoretical, they were immediate and binding. The family's grasp on the inheritance slipped away not through argument, but through the simple, inexorable application of the terms they had ignored. The truth Grandpa protected remained untouched while their claim collapsed under its own weight. Tension thickened as Kevin stood abruptly. He pointed straight at me. Your Honor, my sister deliberately isolated our grandfather in his final months. She restricted visitors, controlled his communications, and pressured him into signing documents that favored her exclusively. The accusation rang out sharp and calculated. Uncle Keith and neighbor Sheila, please come forward and corroborate. Keith rose reluctantly from the rear, his shoulders hunched. When the judge prompted for specifics, he paused before answering. She was always around. We tried to check on him, but she made it difficult. Access was blocked. Sheila joined in, her voice wavering. She managed his phone and mail. We were cut off completely. The judge narrowed his eyes. I need concrete details, dates, conversations, documented attempts, or any record of restriction. Keith shifted uncomfortably. I recall a few times we called and got no answer, but no exact logs. Sheila added, we heard she changed his routine to keep him dependent. The judge pressed further. Medical reports, prior complaints, police involvement, or adult protective services documentation. Anything tangible. Kevin cut in. He was vulnerable. She exploited that. He didn't want family drama, so he stayed quiet. Elizabeth nodded vigorously from her seat, her eyes urging the witnesses onward as if silent encouragement could fill the gaps. The judge's tone grew firm. This court cannot act on supposition. Present verifiable proof or this line of testimony ends. Olivia rose swiftly. Objection, Your Honor. These statements lack foundation. No evidence has been offered to support the claims of isolation or coercion. The judge sustained the objection. Counsel, the petitioner must provide substantiation, not conjecture. Show me evidence, not stories. Kevin pushed forward. She turned him against us, made him believe we didn't care so she could gain control. The judge interrupted again. I will not permit unsubstantiated allegations to derail a valid trust instrument. If you have medical records, call logs, affidavits, or any corroborating material, produce them immediately. Otherwise, this remains mere narrative. Uncle Keith muttered something about overhearing tense phone calls, but offered no dates or proof. Sheila mentioned seeing paperwork she signed, but couldn't specify content or circumstances. The judge exhaled once. The absence of concrete evidence renders these claims inadmissible for purposes of overriding trust terms. Olivia reinforced the point. The petitioner has offered nothing beyond assertion. The court should disregard this attempt to shift focus. My brother sat down, his face flushed with frustration. The witnesses returned to their places, eyes fixed on the floor, avoiding any further contact. Inside, their accusations twisted in my mind, those peaceful evenings when I brought homemade soup to Grandpa's apartment, sitting beside him, as we talked for hours about his old neighborhood stories, his favorite jazz records, and the simple pleasures that kept him going, the complete antithesis of isolation or pressure. Their portrayal felt not just false, but deliberately cruel. The effort to recast my care as manipulation while glossing over their own prolonged absences made me wonder who was truly orchestrating the deception all along. The judge addressed Kevin directly. If additional evidence exists, submit it through proper channels. This court will not entertain unverified accusations as a basis to challenge a corporate trustee's administration. The room fell into a strained hush, the failed pivot leaving a palpable void. Kevin's strategy to deflect blame had crumbled under the weight of required proof, exposing the fragility of their position. The family's attempt to rewrite the narrative had only highlighted its weaknesses. The judge turned to the clerk. Note the objections sustained and lack of substantiation for the record. The proceedings would continue, but the air had shifted again, the weight of unproven words hanging like smoke. The accusations had failed to land, yet the damage to trust within the family deepened, with every evasive glance and hesitant response. Just then, the clerk announced Theodore Lane's arrival. An older man with a calm, steady gait approached the stand, his voice clear and unwavering from the first word. Your Honor, Victor confided in me directly. He arranged private meetings with his attorney to establish the trust because he anticipated pressure from family, especially Kevin, who made repeated calls demanding Victor sign revised documents immediately to rescue his failing company. Victor said those conversations left him uneasy. He feared his wishes would be overridden, so he chose an irrevocable structure with a neutral corporate trustee to eliminate any chance of coercion. Theodore paused, allowing the statement to settle. The judge inclined his head. Continue. The witness added. Victor was adamant. He wanted his granddaughter protected from exactly this scenario, family disputes over control. He executed everything freely with full awareness. The judge lifted the letter from the trust packet. This is Victor's own written statement prepared in advance. He began reading aloud. If this document is presented in court, it signifies my son and his family are attempting to claim my estate by falsely accusing my granddaughter of wrongdoing. Victor detailed that he invited her to assist after his fall, providing companionship and practical help. He met his lawyer alone, confirmed his mental capacity, and created the trust to shield against manipulation. The judge continued. On the evening my son arrived with a mobile notary insisting on fresh signatures for his benefit, I declined and asked for independent witnesses. When they persisted, I contacted emergency services myself. Each sentence delivered like a measured strike. Elizabeth's eyes filled with redness, but the emotion appeared forced, her posture stiff rather than broken. Kevin surged to his feet. Hearsay, Your Honor. This is inadmissible. The judge overruled immediately. It qualifies under the state of mind exception and aligns precisely with the emergency dispatch record already submitted. Gary's complexion turned ashen. He dropped his gaze to the floor, shoulders sagging as though searching for a hidden exit in the carpet. The judge read the closing lines. Victor stressed he acted of his own volition, no duress, no confusion, only the resolve to ensure his intentions endured beyond pressure from those closest to him. The courtroom fell into absolute stillness, the letter's straightforward language dismantling every layer of their defense. Kevin remained standing, but his objection hung unanswered, his face a mask of contained fury. Brian stayed silent, recognizing argument would only amplify the damage. Elizabeth dabbed at her eyes mechanically, the gesture lacking genuine sorrow. Gary's hands rested limp, his breathing shallow, the exposure stripping away his remaining authority. Inside, Victor's words struck a deep chord. Grandpa's foresight had bridged time to defend what mattered most. The truth had surfaced inevitably, no matter how long it took or how desperately they tried to suppress it. The judge lowered the page. This declaration reinforces the trust's legitimacy and directly contradicts the allegations of coercion or mistreatment. The court finds no basis to question the settler's capacity or intent. The trustee's position stands. The representative from the bank inclined his head slightly. The trustee will administer without deviation from the instrument. The revelations left the room transformed. Kevin lowered himself slowly, his earlier drive extinguished. Brian gathered notes with quiet precision, but the defeat etched plainly in his features. Elizabeth's redness deepened, yet the tears never fell. Gary continued staring downward, the search for escape futile. The family's pivot had backfired catastrophically. Grandpa's letter stood as irrefutable testimony. The accusations evaporated into thin air. The attempt to invert reality had only solidified the original plan. The judge spoke to the clerk. "Enter this into the record and note its corroborative weight. Proceedings will reflect the trust's primacy." The silence lingered heavy with finality. The truth Grandpa safeguarded had prevailed quietly, powerfully, and without compromise. As the letter's words echoed, the bailiff leaned toward the judge and murmured something brief. The judge listened, then spoke directly to my father. Mr. Gary remained seated. Gary froze. "Why, Your Honor?" The judge's tone stayed even. "Because a deputy outside has paperwork for you unrelated to this proceeding." The doors opened. A uniformed deputy entered, document in hand. He approached Gary. "Sir, you have been served. Service of process for criminal investigation into attempted coercion tied to the emergency services call from the night you brought the mobile notary." Gary grabbed the packet, his fingers unsteady as he opened it. The bold header, "Criminal Complaint," stared back. His face turned an ashen shade. Brian Ward leaned close, whispering urgently, but Gary's eyes remained fixed on the pages outlining the allegations. The deputy stood impassive. 2 additional officers positioned near the doors, silent but ready. The judge continued, "This court has no role in that matter, but you are still under oath from prior testimony." Gary forced composure. "Your Honor, this is targeted harassment. My family is under attack because my daughter," the judge cut him off. "Stop. Your daughter did not call emergency services that night. Your daughter did not file a motion activating a no-contest clause. Your daughter did not seek to override a corporate trustee." Elizabeth's lips pressed thin. "We were safeguarding the family," she whispered. The judge remained unmoved. "Then you safeguarded it into a referral." The deputy shifted slightly, his presence underscoring the seriousness. Brian cleared his throat. "Your Honor, we request a short recess to consult with clients." The judge regarded him with visible fatigue. "You may consult, but the motion stays denied. The trustee administers the trust. I will set an order to show cause for sanctions on the filing and representations made." He lifted his pen, then paused. "One additional matter." He turned to the bank representative. "Does the trustee seek any protective relief?" "Yes, Your Honor. Given the pattern of interference, including today's petition and now this criminal service, The trustee requests an order barring petitioners from contacting financial institutions, custodians, or third parties regarding trust assets and prohibiting harassment or intimidation of the primary beneficiary. Kevin let out a sharp scoff. Harassment. The judge's gaze shifted to him. You leveled accusations of mistreatment in open court without substantiation. You are hardly positioned to question the term. Granted, the judge said. Prepare the draft. I will sign today. Elizabeth's face lost color. You cannot bar us from our daughter. Her voice trembled. The judge replied, You can bar yourselves from further misconduct. Olivia murmured beside me. This secures the strongest possible safeguards. I nodded, my attention fixed on my parents. Gary clutched the criminal papers, his earlier aggression replaced by frantic calculation. The judge adjourned. Court is recessed. The gavel struck. My mother advanced in the aisle close enough for her words to cut. You caused this. You destroyed your father. I met her eyes. He destroyed himself, I answered quietly. Kevin stepped nearer, his whisper venomous. You will lose it all. I will ensure it. I held steady. You tried already. The trustee handled it without raising its voice. He turned his phone face down, concealing whatever he had already set in motion. Olivia caught the gesture, her eyes flicking to his hands, then mine. Do not engage. We are leaving. We left through the side exit. The courthouse air outside crisp and bright, oblivious to the wreckage inside. At the curb, Olivia stopped. The result is concrete. The trust governs fully. The petition dismissed, the clause enforced. Your father now faces criminal process. Your brother forfeited today. We paused. The city sounds distant. Then Olivia's phone vibrated. She checked it, her face tightening. Security alert from the trustee. Attempted access blocked. My pulse quickened. The hearing concluded, the order issued, yet the effort persisted. Olivia dialed the trust line immediately. A composed voice answered. This call is recorded. How may I assist? Olivia Klein, counsel for Kimberly Scott. We received a security alert, attempted access blocked. Details, please. The response came prompt. Attempted login to beneficiary portal, failed multi-factor authentication, followed by immediate request to alter contact number. Blocked at both steps. Manual fraud flag applied. Distributions held pending review. Olivia exhaled. Good. Lock all modifications. No changes without verified in-person identification. Already implemented. Report generated. Forward to my office. Note the active protective order. Understood. The call ended. The silence afterward crisp. Olivia met my eyes. That alert demonstrates precisely why institutional trustees exist. They record, block, and enforce no emotion, no negotiation, pure procedure. We headed to her office to finalize protections while my family unraveled. Olivia prepared instructions routing all trust communication through counsel, rejecting direct family contact, treating any alteration attempt as fraud. She sent the report to the judge's clerk, time-stamped attempted breach minutes post-recess. No rhetoric, just evidence. An hour later, the trustee representative joined via video, the same composed demeanor. Miss Scott, the trust distributes, strictly per terms, no family pressure exceptions. No interim advances. Due to today's petition and portal breach, the trustee deems Kevin triggered the no contest clause. His share forfeited pending confirmation. Your parents' contingent interests under review for coordinated conduct. We will submit declaration. The administrative finality hit, not dramatic but absolute. The record had ruled, the family's grasp broken beyond repair. We stepped out into the hectic New York streets that afternoon, the city noise drowning out the courtroom echoes. Olivia's phone buzzed. She glanced at the screen, and her expression sharpened. Security alert, trustee system attempted login blocked. She dialed the trust line without hesitation. The response came prompt. This call is recorded. How may I assist? Olivia Klein, counsel for Kimberly Scott. Alert details. Attempted beneficiary portal access failed multi-factor authentication. Immediate subsequent request to update contact number blocked both steps. Fraud flag activated. Distributions frozen pending review. Olivia's voice stayed firm. Lock all access points. No alterations without verified in-person identification. Already enforced. Report generated. Forward to my office. Note the protective order in effect. Understood. The line went dead. The silence that followed felt charged. Olivia looked at me. That move minutes after recess proves why corporate trustees exist. They detect, block, and document no room for pressure, no override. We headed directly to her office to finalize safeguards. Olivia drafted instructions channeling every trust interaction through counsel, rejecting any direct family outreach, treating alteration attempts as fraud. She forwarded the report to the judge's clerk, timestamped attempted breach post-recess, pure unfiltered evidence. An hour later, the trustee representative appeared on video call, same unflappable composure. Miss Scott, the trust executes distributions solely per instrument terms, no concessions to family demands, no temporary advances. The petition and portal breach confirm Kevin triggered the no contest clause. His interest forfeited pending final confirmation. Your parents' contingent shares under review for coordinated participation. We will submit declaration. 2 weeks passed. The sanctions hearing convened. Kevin's attorney rose, cleared his throat, and stated, "Your Honor, we withdraw all contested assertions and apologize for the filing." The judge received the statement, without softening, imposed sanctions for bad faith, thousands of dollars in fees, entered order, affirming trustee enforcement of the clause, and addressed my parents directly. Your conduct sought to circumvent documents your father executed. This court declines to participate. The trust proceeds with first distribution, house titles, secured assets, handled receipts, confirmations, trail unbreakable. I received the initial notification, thousands of dollars transferred, then blocked every family contact number, no messages, no calls, no indirect channels. The fallout unfolded swiftly. Kevin's major business deal collapsed. The court scandal repelled investors. His company faltered under the strain. My parents covered court fees, thousands of dollars. The protective order imposed long-term restrictions barring access to financial entities, or no communication permitted. The separation became absolute. I severed ties, completely turned away without backward glance. No lingering ties, no reconciliation. The rift permanent. Grandpa's structure had prevailed. The trust preserved what he intended, shielded from those who would have claimed it. The lesson crystallized in America: establishing a trust early can protect against family conflict. Consult a lawyer today to secure your genuine wishes. The story closed, not in rage, but in measured finality. The record unalterable, the inheritance intact, the family assertion dismantled. If this story hits close to home, share your thoughts below. Sometimes the best lessons come from stories like this. Thank you all for taking the time to watch the video. If you found this story meaningful, don't forget to like, leave a comment sharing your thoughts, and subscribe to the channel so you don't miss any upcoming videos.